Well, now we have Richard Akinola, the handling of the recent post-election litigations, may have served to place Nigeria's judiciary on the front burner in a way that has not been seen, at least since the return of democracy in 1999. With public expectations sky high at times, and in some situations, the expected role of the judiciary as the last hope of the common man has these past few weeks and months been dissected and scrutinized, not just by those who are equipped with the right kind of knowledge to do so, but also by those who only acclaimed rights to hold the courts accountable has been nothing more than sentimental. Well, Richard Akinola is a lawyer and journalist. He joins us now to look at the possible ways and means of reforming Nigeria's judiciary. Good to have you on Newsday. Welcome
Thank you.
To the studio.
You're welcome.
All right, on reforming Nigeria's judiciary, we've all watched and we also discussed this clerical error that has happened in Kano State. It seems that the appellate court or the appeals courts are going through quite a lot right now. In terms of something quite small or quite large like that, where do we even start from if we have CTC judgments that have not only typographical errors, but huge chunks of paragraphs that negate each other and confuse not only the public, but the individuals who are receiving it in order to clear up whether or not they will be governing the state? What do you make of?
Well, I want to describe it as a purported clerical error.
Purported, why?
Because to me, I haven't gone through the whole CTC judgment. I can't fathom how that could be described as a clerical error. Perhaps sometimes the way my name is being written, I'm Akinola. Some people call it Akinola, which is a different thing. I had filed a case before in which I was the claimant, and in the judgment, my name was spelled as Akinola, not Akinola. Those are clerical errors. So, and usually when judgment is given, particularly when you have injunctive reliefs, and there's what is called enrolled order, which is just about 3-4 pages, where the DCR, the Deputy Chief Registrar, will bring out the particular order and which the judge will sign. There are instances where there could be some, clerical errors, maybe when you want to refer to as interim injunction and you mistakenly say interlocutory injunction. These are some few clerical errors. But in a judgment where there are specific paragraph, giving judgment to a particular person, and then going ahead saying that the first respondent, and that's the APC, awarded 1 million naira costs. That couldn't have been clerical error. To me, as far as that is the judgment, because the last paragraph, that's the judgment. When you say that the judgment of so tribunal is reversed, that couldn't have been clerical error. That is definite statement being made. And it's quite unfortunate, what happened in that particular instance, because I found it quite scandalous that what was read on Friday, I think it was Friday, the judgment that was read and reported by the media, different from what was in the CTC. So, and I find it curious again that the DCR, Deputy Chief Registrar, now saying that it was a clerical error, that they have the counsel to both parties need to apply now to withdraw that particular judgment and to be given another one. That is not even possible in the first place, because these are election matters that are time bound. Within 60 days, in law, it's called a fontus officio. Once you are through with that judgment, you cannot go back again and act. You'll be acting legally. It's not left for the appellate court. So I think it's not left for the Supreme Court to decide on what is the actual situation of things. But as far as I'm concerned, the judgment have been from CTC. The judgment have been given to somebody as the incumbent governor, as having won. So, and it will be curious to now come back and say that it was a clerical error. You see, I feel concerned when I read some judgments. And look, I've reported this sector for 41 years. And I find it very curious that this kind of thing is happening. Because not just in respect of this matter, if you recall, in the Osun State Tribunal, not the appeal court, not the initial tribunal, when the tribunal was making mockery of Governor Adeleke, that should go and start, doing dancing and lo bugao in a judgment. I mean, you put that one in a judgment. Similar thing in the Kano judge tribunal. Referring to a particular set of people, supporters of a party, in the case as red cap wearing bandits and stuff like that. You don't do that. It's just like saying that supporters carrying members of umbrella carrying members, which specifically could refer to a particular party. It doesn't. When you write judgment, it has to be elevated. You don't descend to that level. And, Lord Dennis said, December 3, 1964, in his address to High Court journalists, and said that justice is not done in secrecy, and that when a judge sits on a case, he himself is on trial. Unquote. That's as far back as 1964, when Lord Dennis said that. So when that particular tribunal, Court of Appeal, has made that kind of pronouncement, which they are not trying to correct, they are on trial, whether by the Court of Public Opinion or even by the Supreme Court, because these are the major issues that will come before the Supreme Court, which will now adjudicate on the propriety or otherwise of that particular judgment.
All right, Mr. Akinola. If I may come in now. You've just given some specifics regarding the problems and challenges we have. But if we want to broaden, our discussions in view of the current, scenarios on electoral matters, which critical areas of the judiciary and, of course, the law would need urgent reforms, and the types, you think?
I think the National Judicial Institute that trains, because each time new sets of judges are appointed, they undergo certain, trainings, and I think the National Judicial Institute need to train a number of judges on writing of judgments. And because it's a different thing, when at the lower court, at the high court level, at the appellate court, at the Supreme Court, how you write judgment and your syntax, your grammatical expression and so on, very critical. Because if now, despite the fact that Lord Denning had left the bench in the UK, have several years, people still make reference to Lord Denning today. Not necessarily in terms of the progressive nature of his judgment, but in terms of how he couched his judgment. For example, even in Nigeria, people make reference to GIC Taylor, the High Court in those days, in the 70s. People still make reference to Kayode Esho, Justice Aniagolu, Karibi White. Karibi White, during his time, even when he was, if there was a unanimous decision, and he just wanted to support, his supporting judgment sometimes was even longer than the lead judgment. So, and I recall that Kayode Esho in 1987, when he was in the judgment of Fahimi and Akilu over the issue of local standard, talked about Cain and Abel on the issue of my brother's keeper. That is the level, the deep level, because you go beyond the issue of legalese. You go into realm of physics, you go into the realm of literature, as a judge, because you make reference to in couching some of their judgments. So I think it's very critical on how judges write some of these judgments. So that's why I felt scandalized when those two examples I made in terms of the Osun and the tribunal in Kano. You don't debase a judgment by making such references. You have to elevate your language and make some quotable quotes, because today we see quotes Okuta, we quote Aniagolu, we quote Kayode Esho. After several years they have led the bench, but now how many quotable quotes can we have now? So coming back to your question, in view of training of judges, not just when they are appointed, but even refresher courses on how, you make comparative analysis of various judgments, where we have missed it, and how the appellate courts have come to say, no, this is wrong, this is not how to do it. Then, of course, the comportment.
If you don't mind me coming in, not quite a lot of people actually know that judges too need retraining every now and then as well.
Sure, because there are 3 professions that require constant training: law, journalism, and medicine. Because these 3 professions, it's quite dynamic, things keep changing. For example, the law of privacy regarding journalism 20 years ago is no longer a law of privacy. Things have changed. The same thing with law. In terms of local standard, how the various cases filed, fundamental right cases filed under the military, had expanded the scope of local standard, jurisdiction, and the rest of it. The same thing with medicine. So we have to. It's dynamic. We have to keep on changing and read widely. And of course, if in law and judges can make quote serious quotes on Latin terminologies. So it is part of the training. So, and that's why your language has to be elevated when you write judgment, that even if the appellate court will disagree with you, sometimes they have to praise how deep this particular judgment was. See, although the issue of corruption is part of it, in 2020, ICPC came out with its report of 2018 to 2020, and said that the judiciary, the corruption in the judiciary came, or the highest. That 9.5 billion given and offered and received. Mm-hmm. So that shows, is the depth of the corruption in the judiciary. But again, it would be unfair for me to make general statement that the judiciary is corrupt. No, we have fantastic judges, brilliant judges who are still on the bench and are doing fantastically well. But again, when it comes to political cases, political exposed cases, of course, now the issue of Nigeria is very difficult for Nigeria to actually believe that, the justice has been done, because justice has to be rooted in public confidence. And so, then if the public begins to say, no, forget that one, we already knew, and that's how the judgment will be. So, and which was not like that. Mm. Because in those days, even when you lost a case, you will praise the judiciary that even the dissecting judgment. Now, how many times do we have dissecting judgment? It's usually unanimous. Even at that time, I remember the 1979 Awo Shagari case. There was a 6-7, 6-1. Kayode dissected. Even Obaseki, Justice Obaseki, even though he agreed with the majority decision, but in his own judgment, he disagreed, on a different level. Mm. So, and these are so many things that people need to study and make deep research in terms of how judgments were churned out in those days and now. So, which is a major challenge that we have. So, again, judges, by their disposition, they are not supposed to be overly social. But these days, you have seen many judges going to parties, maybe go to Island Club, go to Yoruba Tennis Club, mixing with people, and those who are likely to be litigants in your matter. Judges are supposed to live a reclusive lifestyle. They are not supposed to be found, mostly among people, but that has changed, which shouldn't be. And these are some of the issues that impact negatively on the image of the judiciary.
Ooh, there was a lot to unpack from what you said. I do want to disagree with you slightly on some points. Okay. It seems like times have changed. Maybe back in the day, judges were supposed to be recluses, but they're not called to the religious cloth. They are still human beings. And I think there is an element of engaging with the public and just being rooted in reality in order to help them make better judgments for the Nigerian populace. But I do want to question also the training of these judges. I know you said that in certain professions there needs to be constant training in order to stay up on top. And as journalists, we understand. But we also understand that the entry level to the profession should be quite high, because some individuals, for whatever reason, their capacity to learn, grow, adapt is restricted. Yeah. And those are the ones that shouldn't be put in professions that require them to learn, adopt, and change. And it seems that we have an influx of, even though you say there are very good judges, we have an influx of individuals who are not properly educated on the base level, not only just mental education, but emotional education. I mean, someone who is very well read is, different from someone who's emotionally adept. Someone who is emotionally adept won't write crazy things in CTC judgments to ruin their reputation and the reputation of their colleagues. Those kinds of things. Should there be higher bars as to who they accept into these law professions and more screening, because it seems that it's gone too far. Most of them being put in high positions, and now we're discussing situations that even a university student would be thrown out of school for. Like this CTC judgment, if someone submitted their paper in university, they'd be chucked out. It would be the end of their university career. But these guys are allowed to hold on to their careers. They are deciding the future for us. How did they get there in the first place? What can the National Assembly, I don't even know who to call to ask for help, what can be done to better screen these individuals before they get there? And on the other side, what can the National Assembly and the rest do to maybe make their casework less burdensome? Because we do know that typographical errors, clerical errors, cut and paste errors happen when there's a rush job, and we know that the judiciary is overburdened. So is it that they need to implement technology more? They need to pay them more? What exactly can we do in order to get the crop of individuals that are defending us at the bottom line to be the intellectuals that we need them to be in this country?
If I make a reference to UK, for example, or maybe to US, almost all the judges, have complements of researchers. You have IT people, and and of course the proceedings are electronically recorded. Unlike what happens there, that you have to manually record everything, and it takes a toll on the judges themselves. And that's why sometimes you see them aging so fast because of the tedium of writing on a regular basis. Unlike their counterparts, maybe in UK or US, that you have electronic recording, and thereafter you have all the various complements of researchers that will bring the various elements of judgment, citations, and it makes it so easy. But that's a major challenge we have. I know that when Oshibajo was Attorney General in Lagos, for example, he tried to introduce the electronic recording into our court. I'm not too sure that is still working now, because judges still have to use longhand writing. The Supreme Court is overburdened. There are over 2,000 cases in the Supreme Court. You have how many judges? The full complement will be 21. But now,
13.
Now we have fresh people being appointed. So, but how to clear those backlog? And of course, because political matters are time bound, so it gives priority. They give priority to political matters. Meanwhile, there are other cases, fundamental rights cases, and various issues that are just gathering dust there, and it puts so much pressure on the judges themselves. And in the process, of course, mistakes are bound to make and to be made. And of course, maybe quickly, let's try to dispose of this one so that, because once you miss that particular time, it's just like the normal course of proceedings, not political matters now, but normal case. You have a particular period of time after end of submissions and the close of submissions, judge must deliver particular judgment. So, and if you have several of such, so you are put under so much pressure when you don't even have research assistant and to help you and stuff like that. So that it puts so much of pressure on them. So that's one downturn of our judiciary. And of course, when it comes to the issue of appointment, as you rightly raised, you see, who will be the one to screen? The same human beings, the same judges themselves. They have their own preferences. So that's, of course, there are some governors who do have preferences. Politicians, in the National Assembly you mentioned, some of them have preferences because they know that their case will always come before the Supreme Court. I mean, just like the scandalous one of Ahmed Lawan. I mean, who did not take part in the primary, and he won the case in the Supreme Court, and that was quite scandalous. So these are some of the things. So the National Assembly cannot even actually help in that regard because they have interest. They have, they have interest in that matter. So it's a matter of personal conscience. Because in those days, a number of lawyers refused to be elevated to the bench because they felt like, well, look, let me make my money as a lawyer. I mean, how much am I going to be paid as a judge? And of course, because that if I become a judge, I can't move out anyhow. I can't go to these parties. But now, I mean, it's real. I mean, it's a real deal to become a judge. So the competition becomes so high, so rife. So it's a major challenge, which I don't know how the NJC will have to navigate that one. And of course, don't forget that the NJC itself, has its own issues. If you recall that in 2012, now this the Sokoto election, I did a book on that. I wrote a book on that, on the Sokoto election debacle and the Supreme Court, because there was a major issue arising from the Sokoto governorship election, and which led to the suspension and of eventual retirement of Justice Ayo Salami. He had issues with the Casino Alu, who was the CGN, and it was back and forth. So I did a book on it later in 2012, and of course, so these are some of the issues that always arise, and we have to deal with it. Well, I think it's work in progress, as we keep on saying. Yes, despite the embarrassing thing we saw in the Kano Tribunal, Court of Appeal, but it's still work in progress. But I keep on insisting. It's not left for Supreme Court to decide on that one, but I felt it's scandalous. I find it scandalous to say it is a clerical error. No, come on.
And I think even the vulnerability and flexibility issues we raised about Supreme Court judges, I remember even in the United States currently, a black judge, a nominee, is currently being investigated over campaign funds and other issues into
presents and
parties and stuff like that. So I guess Nigeria is not also immune to scenarios like that. But let's talk about the Constitution now. Is there a need to tinker with it, or at least review it, to make it align more in contemporary realities regarding judicial reforms, you think?
Yes, and there have been quite a number of them, like the current provision of Section 285, subsection 7 of the Constitution, where, you have 60 days which each Court of Appeal must deal with these election cases. It wasn't in the original Constitution. It's part of the amendment in the Constitution, which, of course, I think the issue goes beyond just constitutional amendment, and it has to do more with current reality of a judge. Would I want to leave my name in gold? Let me give an example. In 1984, when Buhari was military head of state, there was this issue of Saidu Garba versus federal government on somebody was interdicted, was not interdicted, and became a content matter. So the judge, Justice Yahya Jinadu, gave an order which was flouted severally by the military government of Buhari. So then the NJC, headed by Justice Chiwemo, now the CGN, now went into the matter and asked him to apologize to the executive over the way he handled the matter. And the man said, I would rather resign from the bench than apologize to the executive. That is conviction. And he resigned. By the time Jinadu resigned, he had no house to go to. He had no house. So he just died, a few years ago at 92. I'm talking about somebody who resigned in 1984. I wrote a book on it. That was my first book in 1989, Salute to Courage. So we have people like that, out of conviction. So it goes beyond the issue of constitutional reforms, that there could be lots of constitutional reforms, but the person who is in charge, why is it that today people still talking about Lord Denny? It's a matter of, I want to leave an imprint in the sense of time that the generations yet to come will continue to make reference to what I'm doing. That's why if people talk today, talk about Kayode Esho, talk about Okuta, talk about Anya Golu, talk about Muhammad Uwais. These are people who had left the bench several years ago. So it's a matter of personal conviction that I will do justice and fairness no matter who asks God.
It seems that personal conviction often comes in conflict with monetary gains and ego pacification. Well, Mr. Akinola, you have lots of material to write another book out of from all these judgments that are coming out. Can't wait to see what that one will look like. Thank you so much for joining us here on Newsday for this very interesting conversation.